It's Wednesday morning there. If you don't see the message, you should know that session will be recorded and eventually will be up in case you missed some of it or want to see it again, or there are others. Of course, the previous ones are up and available as well if you missed them. Um, First of all, I'd like to thank Mary Bloodworth for making everything electronic possible. And without her, there wouldn't be these. I'd like to thank Jean Daniels for publicity and Karen Struck as well, and Judy Berman as well. Trudy wrote all this down for me just in case you want to know, so I don't forget anything. Um, I just wanted to explain to you, the next Village Voices will be on Monday, February 5, and we'll have Benjamin Applebaum, who is going to talk about the economics of housing and especially why we don't have enough affordable housing, especially for the elderly. And he's also going to talk about, he's going to critique the roles of historic districts and how it affects the availability of housing. You may or may not recall he wrote an editorial a few months ago being critical of historic districts as limiting the amount of affordable housing in the city. So it'll be interesting to hear his opinion and be able to ask him. And then in March, with a date to be determined, will be Fergus Bordowich, who is writing a book about Ulysses S. Grant and his war with the Klan, which I'm a Grant fan, but I don't remember anything about that. So I'm going to be sure and be there because that should be quite interested. You'll have to watch the newsletter to find out uh, what date it'll be. Now, I hear somebody in the background, so somebody doesn't have their sound muted. So if you haven't muted your sound, please hit the mute button. And then when you want to talk, please try and remember to unmute yourself. And the other thing is we'll allow questions at the end, but if during the lecture you hear something that you really want to comment on, please use the chat room because you may forget what the question is by the time we get to the end. So go ahead and write your question in the chat room and we'll be sure and get to that. Now, our speaker tonight is Stephanie Pell. She has quite a long resume. I'm not going to read it all to you, but she has worked at the Department of Justice. She's been a lawyer for the House Judiciary Committee. Uh, her field of interest seems to be national security and the use of data that is out there on the web. I'm sure she'll correct me if I'm wrong. She is currently with Brookings Institution, and I don't see this written down here, but oh yes, it is. I found you on Lawfare, which looks to me is like a blog. Is that a fair way of putting it? Yeah.
Sure. Yep.
Yeah, okay. Which I actually read some of that too, so today. So anyway, what she's going to talk about is about how uh, state laws are going to have an impact and the use of data on obtaining abortions and the impact of that. So, Stephanie, you can now go ahead and correct everything I've said and take it away.
Not at all. Thank you so much for the kind introduction, and it is a pleasure to meet you all virtually. As Gary mentioned, I'm currently a fellow at the Brookings Institution and a senior editor at Lawfare, and I mostly do national security, cybersecurity work, data, and privacy. But when the Dobbs opinion leaked in 2022, it sort of awakened in me again some concerns um, a background that when I was in graduate school and law school, I will share with you that I was a counselor, a part-time counselor at a private abortion clinic. And this was in the 90s. I know I'm dating myself. But we all watched the changes in the court that took place over the last administration, but I didn't well, I didn't want to ever have to think about the fact that women would lose their right and access to terminate a pregnancy. And that is exactly what has happened. And what I learned from my early to mid 20s working in this clinic in Durham, North Carolina, through now, the changes that I saw made me want to engage with a dear colleague who is a professor at Duke University on privacy and surveillance issues surrounding abortion post-Dobbs, things that we may not have thought about in 1973 and before Roe was the law of the land. And so my colleague Joe Lindellinger and I have spent about a year doing deep dives into state laws, how laws are criminalizing abortion, using our backgrounds as surveillance scholars to think about how law enforcement may use new technologies to do investigations surrounding the criminalization of abortion in a post-Dobbs world. And we have written what is looking like a 106-page paper that is going to be published sometime in early April, we think, in the Duke Journal of Constitutional Law and Public Policy, that is entitled Bodies of Evidence, the Criminalization of Abortion and Surveillance of Women in a Post-Dobbs World. And what I want to do is talk about some of our research, give you some insights into some things that we thought about and saw in doing this research, and open it up to your questions. We are still in the editing process, so questions that you have may really help us improve the paper before it is ultimately published. So as I mentioned, this paper is essentially looking at risk post-Dobbs, that pregnant people will be criminalized, surveilled, prosecuted, and investigated for self-managing an abortion. And I want to be clear up front that our research focused not only on new surveillance technologies, but another kind of disruptive technology that wasn't available pre-Roe. And that is, and you all may have heard about this, medication abortion. Now, up to about 11 weeks, a pregnant person can take two kinds of pills, mifepristone, followed by another drug called misoprostol, that will cause the person to expel the pregnancy tissue. And so that person can essentially have an abortion in the privacy and safety of their own homes. And one of our big arguments in this paper that I just want to put out there up front is that with medication abortion, this ability to self-manage an abortion in your own home, where you can potentially receive pills in the mail and have a telehealth appointment with a provider even overseas who can mail these pills to you, that the existence of medication abortion and that telemedicine process will disrupt the ways that that states and police regulate abortion and investigate it in a post-Dobbs world. Think about it. What we have seen states do is write laws that certainly target providers, pass bans on abortion that cause clinics to close down. And that essentially means, that normally someone then would have to travel to another state to get a physical abortion. But with medication abortion, that process is disrupted. You can, again, up to 11 weeks, you can self-manage an abortion in the privacy of your own home. So what we hypothesize is that if states, and I hope this isn't the case, but when we've looked at some of the rhetoric and some of the laws that I'll share with you, that if states are serious about stopping abortions, they're going to have to look at other tactics beyond shuttering clinics and threatening to prosecute doctors and providers. And these other tactics can potentially include the investigation and prosecution of women and family or friends that facilitate their access to medication abortion. But in a post-Dobbs world with modern days technologies, if they decide, prosecutors and police, to start investigating women and their friends or family who help facilitate their access to medication abortion, those investigations are going to involve modern day surveillance with modern day technologies. Now, what you're not going to hear me talk a lot about in this presentation is the prosecution and investigation of women who travel out of state to obtain abortion care and the people that help them. And I want to say prosecutors in states that ban abortion could certainly try and do that. And you all have probably heard discussions on the news or in the paper that there are some constitutional principles that protect the right to travel. I hope those, whenever we see that a case, I hope those principles hold. But right now, those principles have not been applied to a case post-Dobbs. And those issues aren't going to be the subject of this talk. But if you're interested, I can recommend a really great paper that looks at those issues and all of kind of the interstate conflicts that arise if, let's say Texas wants to prosecute a woman who goes to California to get an abortion. So then, let me start with making sure that I set the stage so that we're clear on terminology. So when I say a self-managed abortion, that generally refers to abortions obtained outside of the traditional healthcare system, such as when a pregnant person buys medication online directly from an international pharmacy or interacts with an international or out-of-state provider via telemedicine, who then either ships the medication directly to the pregnant person or orders a prescription from an international pharmacy for them, and that pharmacy then ships it to the pregnant person. Now, of course, pregnant people may also acquire medication to self-manage abortions from friends, from family members, or another third party without first obtaining a prescription. Just like people obtain medications without prescriptions in other ways, other kinds of medication. It can certainly happen with respect to medication abortion as well. You will also hear me use the term women, pregnant people, and people who can become pregnant. My use of women recognizes that both current and historical discussions about abortion implicate the treatment of women as a group, gendered societal and religious stereotypes about motherhood and femininity, and laws and decisions that have specifically mentioned or applied to women. I use pregnant people and people who can become pregnant to recognize the broader category of people who face reproductive health issues and pregnancy, as well as surveillance and privacy issues arising in the wake of the Dobbs decision. And so we intend to be inclusive. My co-author and I, in writing this paper, we wanted to be inclusive in our attempt to explore the consequences of the criminalization of abortion following Dobbs, while also conveying the ways in which the historical treatment of abortion in the United States relies on both stereotypes and discriminatory treatment of women. And I also want to stress as a final caveat that as with most discussions about surveillance and privacy, it is important to acknowledge at the outset that privacy has and access to abortion has been less accessible to people with lower incomes, people of color, young people, and marginalized groups in the US. And these groups are often disproportionately targeted by surveillance. And thus, abortion-related surveillance will probably have a disparate impact on the privacy interests of individual members of these communities. And also, I'm talking about one kind of impact of Dobbs, privacy related. But it is also important to acknowledge that the Dobbs decision has wide-ranging impacts on many aspects of the lives of women. We have heard recently in the news about the plight of a woman named Kate Cox, a woman who was living in Texas and whose health and ability to have children in the future was put at risk by continuing to carry a fetus that received a fatal diagnosis. Ms. Cox obtained a court order to obtain an abortion, but Ken Paxton, the Texas Attorney General, appealed to the Texas Supreme Court and threatened to prosecute any doctor that performed the abortion on Ms. Cox. The Supreme Court ruled that Ms. Cox's condition did not satisfy the statutory exemption of a, quote, life-threatening physical condition, and Ms. Cox had to leave Texas to obtain an abortion. There are many more stories that have been on the news of conduct and circumstances like that. I'm not going to dive deeply in them, but I think it's important to acknowledge that Dobbs has wide-ranging impacts on the health and privacy of women's lives. But to the focus of my paper with my colleague, Professor Dellinger, the Dobbs decision also exposes pregnant people to the risk of being investigated and prosecuted for having a miscarriage or an abortion. And why is this? Well, Dobbs, terminated the right of a woman to terminate her pregnancy and explicitly handed the authority to regulate and prohibit abortion to the people and their elected representatives. And nothing in the Dobbs decision, like just reading the Dobbs decision, indicates that a state cannot completely ban abortion without exceptions and criminalize those that obtain abortions or assist others in doing so. And post-Dobbs, we've seen some very concerning statements from state attorney generals and prosecutors. And I want to give you one example right now. The Alabama Attorney General, Steve Marshall, has indicated that even though Alabama's Human Life Protection Act, which says that no woman upon whom an abortion is performed shall be held criminally liable, it doesn't provide an across-the-board exemption from all criminal laws, including the criminal endangerment of a child law, which the Alabama Supreme Court has affirmed and reaffirmed. So in Alabama, we have this law that went into effect after the Dobbs decision that basically outlawed abortion, but it had this exception in it, which I just read, that no woman upon whom an abortion is performed shall be held criminally liable. Now, the state AG has to acknowledge that, but insofar as he is interested in prosecuting women who may take medication abortion, who may self-manage their own abortions, he has already said that there are other criminal laws that could apply to that conduct. And what you might not realize, my colleague, Professor Dellinger, and I didn't know this until we started sort of digging in to things that happened even during the Roe era, is that women in America have been investigated, prosecuted, and incarcerated for different kinds of pregnancy outcomes. For using drugs, for example, that harm a fetus. This is the chemical endangerment law that I just mentioned. For child endangerment, for self-managing abortion, for falling downstairs while pregnant, suspicious stillbirths, refusing a cesarean section, causing an abortion after 20 weeks, and there are other examples. And just this year, or actually the end of last year, I forgot, we are only a few weeks into January, but just at the end of last year, a group called If, When, and How that assists women and who are prosecuted based on pregnancy outcomes. They did a study that identified 40 cases of people who have been criminally investigated or arrested for allegedly ending their own pregnancies across 20 different states between 2000 and 2020. And I point out to you, if it wasn't readily apparent, that was during Roe, when Roe was the law of the land. And they point out that the cases and arrests were not isolated to states with statutes that were designed to specifically criminalize self-managed abortion. Instead, these prosecutors applied criminal laws meant to address the mishandling of human remains, concealment of birth, practicing medicine without a license, child abuse and assault, and murder and homicide. And those statutes were applied to allegations of self-managed abortion. And just in the past few months, very sadly, we've seen a case of a woman in Ohio who sought treatment for her pregnancy and then had a miscarriage, and sorry for the graphic language, but that occurred at, I believe, when the fetus was approximately 20 weeks or over, and the miscarriage occurred at her home when she was in the bathroom, and she tried to flush the fetus down the toilet, and she is now being investigated for her disposal of this non-viable fetus. Her defense attorney claims, again, she sought help. She was not given the help she needed. She had the miscarriage. The fetus is not viable, but nevertheless, she is being investigated. And one of the states that I'm most concerned about the risk of women being investigated and prosecuted for self-managing abortion is Georgia. Georgia has passed something called the Living Infants Fairness and Life and Equality, or Life Act, that bans abortion after 6 weeks and is also a so-called personhood law because it entitles a fetus or a, quote, unborn child to a robust body of rights and protections. Now, the Life Act in Georgia was originally passed in 2019. Now, you might say, well, how is that possible? That's pre-Dobbs. We didn't get Dobbs until 2022. Well, a lot of times legislatures pass these things. They're generally called trigger laws that are sort of waiting in the background, lurking in the statutory codes for when there is a change in the law, like Dobbs, and all of a sudden then they become valid law. So the Life Act, which was passed in 2019, states that it shall be the policy of the state of Georgia to recognize unborn children as natural persons. And it defines natural person as any human being, including an unborn child, and defines unborn child as a member of the species of Homo sapiens at any stage of development who is carried in the womb. So again, Georgia is giving the full panoply of rights that exist under the law to the fetus at any stage and development. And when we think about the implications of this, by including unborn child in the definition of natural person, the Life Act raises the possibility that a woman who obtains or self-manages an abortion after 6 weeks could be charged with murder. In Georgia, a person commits the offense of murder when, and this is interesting, it uses the word he, but he is supposed to refer to all of us, when he unlawfully, with malice aforethought, either express or implied, causes the death of another human being. And again, human being can be a fetus at any stage of development in the womb. No exemptions from prosecution for the pregnant person are provided in the Life Act. And while there is some ambiguity based on some case law, if you make a comparison to some case law in Louisiana about whether a woman having or self-managing an abortion could be prosecuted for murder under Georgia's Life Act. The Douglas District Attorney, his name is Ryan Leonard, indicated that women in Georgia should, quote, prepare for the possibility that they could be criminally prosecuted for having an abortion. He says, if you look at it from a purely legal standpoint, if you take the life of another human being, it's murder. So with all of that background, I'd like to address the surveillance implications of the criminalization of abortion in a post-Dobbs world. And to begin to do that, I think it is useful to reflect back on a 1965 case. And this case was one called Connecticut v. Griswold, where the Supreme Court considered the constitutionality of a state law that criminalized the use of contraceptives. And the Supreme Court found the law to be unconstitutional, at least as it applied to married people. And just so you know, then in 1972, we had another decision called Eisenstadt v. Baird, which established the right of unmarried people to possess contraception on the same basis as married people. So back in 1965, it was only married people that had a constitutional right to use contraception. But the reason I bring up this case is because there is a very interesting surveillance and privacy point that is embedded within it. So when the court examined the consequences of a law that would criminalize a married couple from using contraception, the court recognized that criminalizing contraception would allow the police to, quote, search the marital bedroom for telltale signs of contraception. So, I myself have an image, of the court thinking about what's happening when cops are, have the appropriate authority to break into the house and go into the marital bedroom at all times of night to search under the bed and in the bathroom for telltale signs of contraception. And what I think it's important to appreciate is that, look, in order to do those kinds of searches, they're called, law enforcement would have to obtain a warrant. They would have to go to a neutral magistrate or judge and show that there was probable cause to believe that the place they wanted to search there would be evidence of a crime. So, cop gets a tip that a married couple has purchased contraception and is able to establish the relevant probable cause, gets its warrant. And remember, the warrant is supposed to be a big privacy protection. The Fourth Amendment says that you aren't, the cops, the police are not allowed to search homes and with unreasonably, and because we have a reasonable expectation of privacy in our persons, houses, places, and effects. And what often makes a search reasonable is if you go to a neutral judge and you lay out your probable cause to show that you will find evidence of a crime and you get your warrant. But again, in this situation, the court was grappling with the fact that, wow, even with warrants, the police are going to be able to search marital bedrooms for telltale signs of contraception. So the reference to searching marital bedrooms, which again, in most circumstances would occur after the police obtained a warrant, implies for the Griswold court that even the necessity of a warrant cannot provide sufficient protection against governmental intrusions into our personal spaces and relationships when the investigation concerns the crime of contraception. For the Griswold court, this very idea of the search of marital bedrooms was, quote, repulsive to the notions of privacy surrounding the marital relationship. Now, that was a pre-Roe, pre-internet age case, 1965. So today, in a post-ops world, law enforcement will be able to investigate violations of state laws that criminalize abortion, both by those that have abortions in violations of these laws and others who assist them through the use of myriad modern-day communication technologies and platforms. And unlike the court in Griswold, the majority in the Dobbs court gave, in my opinion, absolutely no consideration to the kinds of surveillance and privacy intrusions into people's lives that would occur through the use of modern-day technologies to investigate violations of laws criminalizing abortion. So what it is also important to appreciate is that in the pre-digital age, before Roe, time and resources essentially had a way of limiting the scope and surveillance, the scope and pervasiveness of surveillance. It took a lot of human effort and hours if you wanted to track somebody. I am old enough to remember, because I'm a former prosecutor who worked on cases before the iPhone came into existence in 2007. I'm old enough to remember when the FBI, because I worked with them frequently, was investigating a case. If they wanted to follow an individual, they had to do so on foot, in a car, sometimes in a helicopter if it was a high profile enough case. I worked on a gun running case involving the Irish Republican Army in 1998 and 1999. And the FBI was trying to follow around a bunch of suspects, and they had to literally have agents on the beat doing that. That was a lot of time and I'm going to say person hours, because there were male and female agents. That wouldn't be as time intensive today, because you can track people using, those lovely smartphones that I'm sure all of you own, or your family or friends own. So post Dobbs, some of the technologies that I'm most concerned about, which facilitate law enforcement investigations for very good reasons in other kinds of investigations, but when applied to abortion-related crimes, give me really cause for concern. And one of them is just what exists on your cell phone itself. In a Supreme Court case called Riley, the court opined that a cell phone search would typically expose to the government far more than the most exhaustive search of a house. I don't know about you, but I try and have good data privacy, but if somebody got into my phone, they could probably learn a whole lot more about me, than rummaging around through my laundry or the drawers of the desk I'm sitting at. And of course, those phones also allow law enforcement to track you, and those phones also generate data such that law enforcement can see who was with you at a particular place and time. Again, they are wonderful instruments for solving crimes. What is also available to law enforcement in the post-obs world that was not available to pre-Roe was all sorts of is search histories on the internet that may be available on your phone, that may be available on a laptop, that may be available from third-party providers. When I looked for information, again, dating myself, encyclopedia, the white book, the yellow book. I mean, that's how we used to look up things. That's just not the case. You leave a data trail of all of the research and things you look up on the internet. So while it may be the case that law enforcement would have to obtain a warrant to get access to all of the kinds of things I'm talking about, I'm gonna respectfully submit to you that as a former prosecutor, that it's not all that difficult to get a warrant. And so my colleague Jolene and I have argued that as sort of suggested by the Griswold court, the necessity of a warrant cannot provide enough protection against governmental privacy intrusions that will occur in the investigation of abortion crimes. The Fourth Amendment is simply impotent in these circumstances. And that's kind of a sad thing to say about the Fourth Amendment, but it's in my view, and this is the subject of another talk, but it's had a hard time keeping up with modern day advancements and technologies. Case law, for those of you who are Supreme Court case law, can be very, very slow to change. But returning to the point that I started with, while Dobbs has significantly limited abortion access through the formal healthcare system, the ability of women to self-manage abortion safely through medication challenges the ability of anti-abortion states to prevent women from obtaining abortion. So that is why I fear, I hope I'm wrong, but we are going to see, more instances of women and those that assist them being investigated for self-managing their own abortions through medication. Now, there are other ways, though, and I have to mention this because the Supreme Court is going to be hearing a case about it this term. There are other ways that anti-abortion activists are taking steps to limit access to medication abortion. In this case, the pill I mentioned called mifepristone, which is the first pill in the two-drug regime that is most often used for medication abortion in the United States. Last year, an anti-abortion group, teamed up with some doctors, and on these doctors' behalf, they brought a challenge in front of a judge with Judge Kaczmarek, who was the single judge in his district in Amarillo, Texas. And what these plaintiffs were trying to do is challenge the Federal Drug Administration, or FDA's, approval of mifepristone way back in the year 2000. That is when the FDA first approved the drug. Over the years, the FDA has loosened some of the restrictions that the drug started with. It used to be that you could only obtain mifepristone by going to a provider. You couldn't pick it up from a pharmacy. You couldn't get it mailed. And so for many, many years, the promise of medication abortion, if you consider, as if one were to consider, as I do, that promise being allowing pregnant people to manage their own abortions in the privacy of their own home, homes, that was somewhat blunted by the fact that there were all of these additional restrictions layered on to the FDA's approval of mifepristone. Over the years, they've loosened those restrictions. Some of that happened because of COVID, when another lawsuit was brought, and a federal judge sort of loosened those restrictions, and then the Biden administration, this was during the Trump administration, and then the Biden administration, came into office, and the FDA started being even more forward leaning. And while there still are some restrictions, for pharmacies that are certified, they can distribute medication abortion. And as I said, at least right now, there is nothing unlawful about mailing the pills through the mail. And so pregnant people can receive them from overseas, from other states. But back last year, there was a challenge to that original 2000 approval. And this district judge, it was a bit of judge shopping in Amarillo, Texas, basically said the FDA's approval was flawed, ordered that the drug be taken off the market. And the government immediately appealed. Ultimately, the matter was stayed. In other words, the lower court's negative ruling did not take effect. And the way that it has worked out is that the lower court ruling and the Fifth Circuit that later looked at the lower court and didn't give the government a full win, but gave it a partial win. The whole case is now in front of the Supreme Court, which will be heard this term. So we will see whether mifepristone remains fully available and accessible in the way that it does now, or if the court does something to narrow its availability. I am cautiously optimistic, given the way the questions that the Supreme Court has framed it wants to hear. But I'm not betting my retirement money on what the Supreme Court will do with that case. So that is just an example of another way, other than the criminalization of abortion, that anti-abortion advocates are working to limit women self-managing abortions through medication. But I want to leave time for questions, and I don't want to end my remarks without giving some positive information to you. So as I mentioned, when Dobbs came about and overturned Roe, the regulation of abortion, the outlawing of it, the allowing of it, turned back to the states. And we have seen some significant abortion bans. We've seen criminalization of abortion across many different states. But we have also seen blue states, some of them, passing laws that seek to protect doctors who engage in telemedicine. And to get at the surveillance concerns I've raised, we've seen some really interesting things. The general category is called shield laws, passed in Washington State and California. And why Washington State and California? Well, these are two very liberal states, but one thing to know about Washington State and California is that a lot of the big tech companies like Google, Microsoft, are headquartered, Meta or Facebook are headquartered in Washington State or California. And so what legislators have done in Washington State and California is pass a law that says, you companies that hold all this data, that hold the internet searches, that hold the Facebook messages, that might show evidence that someone has, facilitated medication abortion or obtained it, you are not allowed to provide that information to another state that is requesting that you do so for an out-of-state investigation. And you know, a pretty forward-leaning thing to do. Now, what we don't know is, let's say, Texas is investigating an abortion crime, and they send a court order warrant over to Meta saying, I want all these Facebook messages between these two individuals from, for these 2 weeks worth of time. You know, how is Meta going to, what process do they have in place to determine that what is being requested is in fact for an abortion investigation? What we have seen is, some of these requests come and they appear to relate to investigations that involve the unlawful disposal of criminal remains. The one case that we have seen post Dobbs is very sad. A mother and a daughter in Nebraska were investigated and prosecuted for unlawful disposal of criminal remains having to do with a fetus that was disposed of after the mother helped the daughter acquire medication abortion. The daughter took the pills. The fetus was beyond the legal limit for the state of Nebraska. And the law enforcement officers got a tip about the unlawful disposal. They started investigating the case. They saw the daughter scrolling through her Facebook messages on her phone, and they went to Facebook with a warrant, and they got the communications, which showed the conversation between the mother and the daughter, that this occurred because of a medication abortion. And so both parties were prosecuted. They have both pled to different offenses and the mother is serving time in jail. So the question now is, like, what processes is Facebook and other tech companies putting in place to sort of root out when these investigations may relate to an abortion crime? Those circumstances are yet to play out, but it is, I don't know what is going to happen if Texas, if Meta says no to Texas, and the case proceeds through the court, because normally states respect other states' requests for cooperation in law enforcement matters. So those issues are yet to be fleshed out. But this is a positive example of the privacy, of the creativity that is happening post Dobbs in some blue states to try and thwart these kinds of investigations. So we've got about, or just under 10 minutes left. Let me leave it there and see if you have any questions, thoughts, comments. I see there's a chat.
So, do we see a hand anywhere? No. I have a question. This seems to me to suggest that if you are a provider of any type of abortion services, that you should have a encrypted cell phone. Is that being done?
So is that being done?
Right. In other words, are lawyers advising their clients who do this, you should get an encrypted, you should have all your employees have encrypted cell phones.
I certainly hope so. I am aware that there is a nonprofit organization that it's not just with lawyers, it's tech folks who actually can teach people how to practice better privacy and security. But I hope so. I think that is all going on. It certainly should be. For another grant proposal I'm working on, I've had the occasion to talk to some providers, and they are much, much more sensitive to these kinds of privacy and security concerns than they used to be.
Right, right. Okay, Howard, you have a question? Please unmute yourself.
Okay.
There you go.
I sent a chat in. I was curious at the term of the fetus being pregnancy tissue. First of all, as an initial statement, I am totally opposed to the Dobbs decision. And I believe that women absolutely have the right to kill their babies. It's a very serious action to do that, but a woman should be in charge of her body. And I think this whole abortion issue is offensive to many people because it ignores what actually is happening. Now, let me tell you, I was recently in Japan, and part of that visit brought us to a Buddhist cemetery where they had memorials to children that died in childbirth, through illness, and from abortion. And I was taken by that. And the guide we had was a young woman who explained that a college friend of hers got pregnant with her boyfriend, and they had an abortion. Subsequently, they got married and had a couple kids, but every year, annually, they prayed for the soul of the baby they killed. They knew what they were doing. And again, as I support a woman's right to control her body, in fact, I had a friend who got raped and got pregnant and had an abortion, and I totally supported that. But I still am offended by the way the left ignores what they're doing. Now, I want to add that I just found an article that I had heard about. It's in the Atlantic in 2018 about how women in England, New Zealand, and some other countries are protected if they have a postpartum depression and kill their babies. They recognize that infanticide can be due to a severe emotional reaction and letting women go into depression after delivering a child. So that's it. That's all I want to say. Thank you.
Thank you, Howard. Stephanie, I think part of it is what language is used to describe the fetus and things like that that's going on.
And I think people have very different opinions and feelings, about when life begins. There are very different religious perspectives on this. And that is some of what makes this issue very, very challenging. I have interest in many aspects of this issue, but one thing that people can have different views about abortion.
Whoop.
What are problems?
Yeah, it looks like she froze. Oh, I wonder if she lost power.
It looks like it, doesn't it?
Yeah, because her room went dark
Yeah.
at the time of freezing. Folks, that may be
Well,
the end of.
right. Well, I was going to just say it. Well, for me personally, I started law school 2 years after the Griswold case, which is a privacy. It was decided on the right of privacy, and it's sort of I find it very ironic that here we are over 50 years later, and that concept now of the right of privacy is being challenged. There are a large number of cases that rely on Griswold and cite the right of privacy for various different types of cases. And people may not have read the Dobbs opinion, but in the dissent, Justice Thomas lists some of those cases and said maybe those should be revisited now based on the Dobbs case. So, I think that was one of the things that I wanted to ask her about was what's the risk now of a large number of cases being overturned because the court's view of privacy has changed. So I've tried to delay for a minute to see if we get her back. I guess we haven't. So I'll stop the segue and say we'll see you on Monday, February 5. One thing I would say is her law review article is available in draft online. I don't have the website, but if you Google her name and scroll down, you will find her authorship of this upcoming law review article. The article I recommend to you in the last segment because it has in there 3 different sort of case studies of how this could happen. It does 3 different types of cases and shows how the rights of privacy and the data can be discovered and used to prosecute people. And that part I found especially interesting. So with that, we'll say good night and see you in February.
Thanks, everyone.